Hello, and welcome to our next lecture. Today we're going to talk about civil liberties. Oh, and this is going to be fun because we're going to get to talk about all kinds of not safe for work topics. In order to understand what is protected by the Bill of Rights and by the Constitution and what is not, it is necessary to go out to the very limits of protection. One thing which we need to keep in mind is that all rights have limits. You have free speech rights, but you don't have the right to slander somebody or libel someone or commit fraud or yell fire in a crowded theater. You have the right to bear arms, but you don't have the right to possess an atomic bomb. You have the right to freedom of religion, but if your religion involves human sacrifice, then you don't get to do it. So there are some limits on all rights. The question is, what are the reasonable limits? And this goes back again to the whole liberty versus order thing. How do we balance the rights of the individual against those of a society as a whole? And the answer is very carefully. Typically in this country, we tend to lean towards the rights of an individual. Typically. But there are some exceptions to this, which we'll talk about. All right, what are civil liberties? These are the fundamental rights of free society that are protected by the Bill of Rights. So freedom of speech, freedom of religion, freedom of the press, right to peacefully assemble, right to petition government for redress of grievances, right to bear arms, no quartering, protections against unreasonable searches and seizures, right to an attorney, right to remain silent, no torture, no excessive bail, etc. What do these actually mean in practice? Well, we can all have our own opinions, but ultimately the Supreme Court gets the final say. And they're generally the ones who have to resolve these conflicts between liberty and order. Oliver Wendell Holmes, famously a Supreme Court justice, famously once said, "The right to swing my fist ends where the other man's nose begins." We'll talk about this. All right, so what's the Bill of Rights? First 10 amendments to the Constitution. Once upon a time, they applied only to the federal government. So Congress shall make no law concerning the establishment of a religion or prohibiting the free exercise thereof. From the First Amendment, applied only to the federal government. It says Congress, right? When the Constitution was adopted, there were, I think, 3 states that still had state churches. Since the adoption of the 14th Amendment, however, which essentially applied the Constitution to the states as well, most rights protected in the Constitution now apply to state governments as well. So a state could no longer today declare an official religion. A state couldn't restrict freedom of speech. States have to follow the same rules typically as the federal government does if they try to restrict any civil liberties. All right, civil liberties are natural or unalienable rights that can't be taken away. They're rights that exist because we're human, and governments can't take them away, and any government which tries to do so is illegitimate. Civil liberties and civil rights are not the same, however. A civil liberty requires no government action. A civil right does. Probably the easiest way to understand this is to think of it like this. Free speech is a civil liberty. The government doesn't have to do anything for you to have free speech. Voting is a civil right. In order for you to vote, the government has to establish a polling location, hold an election, etc. So civil rights are different from civil liberties, though they're both fundamental to a free society, however, and we'll talk about civil rights next. Civil liberties cannot be taken away by a majority. So just because someone may be a member of a religion may be unpopular, you can't take away someone's right to practice that religion, barring some very good reasons, which we will talk about. All right, talked about this already. What we have to do is weigh the competing needs of a community to preserve order against individual rights. And this can be pretty difficult at times. For example, there is a famous or infamous case from Skokie, Illinois in 1978. Skokie was the home of a large number of Holocaust survivors, and the Ku Klux Klan wanted to have a march there, and they wanted to wear German SS uniforms and march through the streets. The city of Skokie didn't want this in their community, of course, so they refused to grant them a permit. So the Ku Klux Klan sued, and they were provided with a lawyer by the ACLU, and the ACLU trolled them a bit, gave them a Jewish lawyer. But the lawyer's argument was this: these people aren't popular. I don't like them myself, but they have First Amendment rights to peacefully demonstrate. And if you take away their rights, you can take away anyone else's rights. The case made its way all the way to the Supreme Court, and the Supreme Court ruled in favor of the KKK. So, point is, we go pretty far in protecting individual rights here against those of the community. All right, so not going to read all these to you. You can read them yourself. Talk about this. Originally, it limited national government, not state government, but through a process known as selective incorporation, they now apply to the state governments as well. For the most part, there's a few that don't, but most of the significant ones do. First thing we need to talk about here, though, is civil liberties in times of war. Here's a problem. We're fighting a war. We're facing possible defeat, possible destruction. What if we lose the Civil War? What if we lose World War II? We may have to give the government more power in order to win the war. And to do that, we may have to give up some of our civil liberties. And this has been a common theme through times of war. Like today, if you fly on an airplane, the TSA which are agents of the government, are going to take a naked picture of you through x-ray machines, make sure you're not smuggling any weapons onto the plane. Then they also pat you down, which means they're going to be touching you in some areas where you probably don't want them to touch you. This is certainly a restriction on your individual liberty, right? But it's to maintain order. It's to empower the government to protect us. Is this an appropriate trade-off? Well, I'll let you decide that. There's been a lot of history here where this has happened, going as far back as the Quasi-War, which was not really a war. It was a sort of a naval skirmish or very small-scale war, which hence it's called a Quasi-War, against France. But it looked like it could blow up into a major conflict. And so in 1798, Congress passed a series of laws known as the Alien and Sedition Acts. And the most infamous of these stated that you could not criticize the government. And if you did, you could be arrested and put in jail. Pretty obvious attack on the First Amendment, right? John Adams signed it into law. So, during the Civil War, Abraham Lincoln used some pretty heavy-handed tactics to win, too. He shut down newspapers, used military tribunals to try civilians accused of endangering national security, suspended habeas corpus, which allowed him to just put people in jail and leave them there for months or years without charging them with anything. Even had a member of Congress deported. During World War I, Woodrow Wilson had dissenters thrown in jail too, including Eugene Debs, who was a 5-time presidential candidate on the Socialist Party ticket. Debs was put in prison because he criticized U.S. entry into World War I. Again, obvious free speech. Debs ran his last presidential campaign in 1920 from his prison cell in Atlanta. World War II, Franklin Roosevelt, through executive order, had American citizens of Japanese descent rounded up and put in internment camps for the entirety of the war. During the Cold War in Vietnam, blacklisting was a thing. People who were suspected of being communist sympathizers were put on a blacklist and they couldn't get jobs. Protesters, civil rights protesters, including Martin Luther King, was wiretapped by the feds because they thought they were a threat to national security. So all these things, so there's a long history of civil liberties being restricted in times of war. Is it always bad to do this? It's a good question. A lot of these things I have tacked off for you probably are pretty obviously wrong. It was wrong, for example, to intern Japanese Americans simply because of the way they looked. It was wrong to listen in on civil rights leaders. It was wrong to make it illegal to criticize the government. But are there times when it might be necessary? Abraham Lincoln, during the Civil War, was facing disunion. His probably response would be, well, we can debate whether or not this is good once the war is over. If we lose the war, the Constitution's not going to matter much. So the answer is there may be times when giving up civil liberties at times of war are necessary, but this can easily be abused. So we have to be very careful if we do this, especially when it's someone else's rights. When someone, put it this way, when someone commits a terrorist act or a huge shooting, something like that, the instinct a lot of times is to crack down on people who look like that person. You have to be careful with that, because that's, I'm sure, put another way. All right, here's an analogy. After 9/11, I remember a poll came out which showed that a majority of Americans said that Arab American citizens should be required to have a special identification. Why'd they feel that way? Because 9/11 had just happened and everybody was afraid. Looking at it today, this seems crazy. You can't single out U.S. citizens just because of their ethnicity over something they personally didn't have anything to do with. Well, in 1941, when Japan attacked, a lot of people were afraid then too, and they ended up sending people off to internment camps for no reason other than they look like the enemy. So this is something you have to be careful of. A demagogue can really take advantage of this. Sometimes the courts will push back on these restrictions, but not much. But not always, I should say. I should say not much. Not always. Sometimes they do, sometimes they don't. One of the worst Supreme Court decisions usually is considered Korematsu versus the United States in 1944. Fred Korematsu was an American citizen of Japanese descent who was sent to an internment camp during World War II. He, like any good American, he sued, and the case went all the way to Supreme Court. The Supreme Court ruled against him. Ruled the government does have the authority to intern people during times of war. So about freedom of speech. Maybe the most fundamental of our rights. It is protected by the First Amendment. However, like I said, it is not absolute. There are exceptions here. Fraud, advertising, obscenity, child pornography, slander, and libel. None of these things are protected by the First Amendment. There's also what's called clear and present danger exception. What does this mean? It means that when there's a fine line between expression and action. If you incite a riot, you can be arrested and held criminally responsible for that, even if you don't take part in the rioting yourself. The clear and present danger is the point at which a speech loses First Amendment protection. You're allowed to give inflammatory speeches, but if people commit violent acts as a direct result of your words, you can be held criminally responsible for that. This is pretty rare that this happens, but it can. This is where cops have a really difficult job when, say, groups like, say, the Ku Klux Klan hold a public rally. The Ku Klux Klan has a right to do this, but if it escalates and becomes violent, then that right goes away. The question is, what point does this occur? And ultimately, a judge is going to decide this. So cops have a really difficult job when they're policing events like this, knowing exactly when someone has overstepped their rights. Hate speech is difficult to define, can be restricted in some very specific ways. Typically, though, hate speech is protected by the First Amendment. About the only real exception to this, where it's not protected, would be cross-burning bans. You can make it illegal to ban the burning of crosses. You probably know from history this is usually associated with threats against African Americans. If someone burns a cross on your yard, it's a good sign that it's be obviously taken as a threat. Flag burning is protected by the Constitution. The Texas versus Johnson case in 1989 ruled that flag burning was a form of free expression and thus protected by the First Amendment. Laws prohibiting only certain speech on selective basis were ruled inconstitutional as well. This also deals with cross-banning, by the way. In 1992, the city of St. Paul in Minnesota had a law which stated that crosses couldn't be burned on the yards of African Americans. The Supreme Court struck this down and said, if you want to have, you can have a law like this, but it has to be across the board. So it would have to be no crosses can be burned on anyone's yard except maybe your own. And later on, the courts in Virginia versus Black upheld that. Governments can punish journalists in some cases for what they publish. For example, for obscenity, if they incite violence, or if they release secret military information which endangers people on the ground. Individuals can also sue for libel. Let's talk about libel. What is this? Basically, libel is slander but written. If a libel means that you say something which damages someone else's reputation, and it has to be either you have to know it's not true or to have published it with a reckless disregard for the truth. So you can't accuse someone of, I don't know, torturing kittens. If you do that, they can sue you for libel, and they can win damages against you. Unless it is true that they torture kittens, because the truth is an absolute defense against slander and libel. Seditious libel is conduct or language that incites rebellion against the authority of the state. So if you were to call for, I don't know, a group of armed citizens to march down to your local courthouse and kill government officials, that would be seditious libel, and you could get arrested for that. Free speech isn't going to protect that. So those are exceptions here. Obscenity. What is this? Well, you know what it is, but you probably can't give a scientific definition for it. Well, you're in good company. A court case, Supreme Court case from 1964, Justice Potter Stewart said this about obscenity. I shall not today attempt to further define the kinds of material I understand to be embraced in that shorthand description, i.e. hardcore pornography, and perhaps I could never succeed in intelligibly doing so. But I know it when I see it. I mean, isn't that how obscenity works? You can't really define it per se, but when you see it, you know it. And things have changed in terms of the culture. Certainly, we're much more accepting and open to sex today and things like that than we were 40 years ago, 100 years ago. Nonetheless, obscenity is not protected by the First Amendment. Nude dancing is also not protected by the First Amendment. Pasties are, fun fact, in case you're curious, but nude dancing is not, which is why cities can have ordinances against strip clubs. Community standards define obscenity, but these are limited. Child pornography is not protected by the First Amendment, but virtual child porn is protected. So in other words, if it's computer animation, it's protected. If it's actual children, it is not. Public libraries do have the ability to implement porn filters, however. Now, these would be examples of what people would consider obscenity, I think. But the courts have to have a real definition for it. And what they have come up with is what's called the Miller test, named after the Supreme Court case in which this was established. In order for something to be declared obscene, it has to meet all three of these parts. To the average person applying contemporary community standards, the work as a whole, not just isolated passages, but the work in its entirety, appeals to sexual interests. The work depicts in an offensive way sexual conduct specifically defined by state law, and the work lacks any serious literary, artistic, political, or scientific value. So, again, this is a little bit vague here, but bottom line is obscenity is difficult to define. But if the court determines a work to be obscene, it is not protected by the First Amendment. This rarely happens, but it can. Freedom of assembly, we got to talk about this too. First Amendment guarantees the right to peacefully assemble. Now, do you have to get a permit in order to have a demonstration on public property? Or the answer is yes, you do typically. The courts ruled that cities can require permits in order to have a demonstration. But this is only so that they can control traffic, not for political reasons. So in other words, you're going to have a demonstration, the city has the right to be informed of that a reasonable amount of time in advance so they can reroute traffic and provide police and things like that. But they can't tell you no based on your ideas. So if the Ku Klux Klan and I don't know, Habitat for Humanity both apply for a permit to hold a demonstration in front of the county courthouse, they both should have the equal chance of getting it. Parades, though, are more limited forms of private expression, and they can be more limited. So parades typically organized by private organizations or people. If the Ku Klux Klan wants to have a float in the Oak Ridge City Parade, then they could be told no in that case. If they want to have a demonstration, though, in Jackson Square, then they probably would be allowed to. All right, right of association. You have the right to peacefully assemble. It also protects your right to associate or not associate with whomever you please. So you run into issue here. Governments and businesses that serve the public, though, cannot discriminate. If you want to ban certain races from your private property, or men or women or whatever, or any group you want from your private property, you can do that. The government, however, cannot, because everybody pays taxes, right? So the government has to protect everybody. A private college, for example, can require you to go to church every week or maybe every day or whatever. They can also restrict you from drinking alcohol on your own time. They can also not allow you in if you're a member of a different religion. A public school like Roane State, though, cannot do any of these things. If you're a business that serves the public, you typically can't discriminate either. So you can't ban certain races or religions from your store just because you don't like them. You can only do it at your home or your private property, though. You can form private groups that do this, though. If you want to form a group that doesn't allow women in, you're legally allowed to do it, or alternatively doesn't allow men in, you can do it. But, of course, you get into some gray areas here. If you're a private organization that bans, women, and you use a public library for your meetings, then the government at that point could either say you either allow women in or you can't use the library anymore, because you get into some gray areas here. But typically you have the right to associate with who you want or who you don't, unless you are a public entity or a business that serves the public. Freedom of religion. Free exercise clause. There's two parts of the First Amendment when it comes to religion. Congress shall make no law concerning the establishment of a religion. That's the Establishment Clause. Or prohibiting the free exercise thereof. That's the Free Exercise Clause. So government cannot favor one religion over another or disfavor any religion over any others. Government has to be neutral. The Free Exercise Clause means that individuals can worship or believe however they want or not at all. Private religious beliefs cannot be criminalized. But there are some limits here. Conscientious objectors, you might know this from history. So there are some religions, Quakers being an example of this, and there's others too, who are pacifists. They don't believe in war. Can the government, during time of a draft, can they force someone who doesn't believe in war to violate their religion and take part in a war? Typically, no, although they have it sometimes in the past. By the way, if you're a conscientious objector, it doesn't necessarily mean you get out of service. It just means that you get drafted and assigned to a non-combat role. Typically, though, conscientious objectors are protected. The only restriction on it is you can't pick and choose wars. So you couldn't say, for example, I believe that World War II was a noble, just war, and I would have gladly served in that, but I don't think Vietnam is a just war, so my religion prohibits me from it. Polygamy, not protected, typically. Racial discrimination, not protected by freedom of religion. If your religion believes races are superior to others. You can believe that, but you can't actually enforce it. Animal sacrifice, however, is protected. The court ruled in the Church of Lokimi Babalu A versus the city of Hialeah in 1993 that animals can be ritually sacrificed, not just for food. The other side of that, the Establishment Clause, Congress can't recognize one church as the nation's official church. You probably heard the term wall of separation between church and state. This actually comes from a letter that Thomas Jefferson wrote to the Danbury Baptists in Connecticut, which he said that his interpretation of the First Amendment was it created a wall of separation between church and state. The phrase separation of church and state, though, doesn't actually appear in the Constitution. This was, however, adopted by the Supreme Court beginning in 1947. The Lemon Test, we should talk about this. This is the Supreme Court test for determining if laws violate the Establishment Clause. So, if you get down to it, so I'll put this in another way for you. If you get down to it, you could argue that many of our laws are based to some extent on religion. Like most religions say it's wrong to murder, right? And we have laws against murder. So can we have laws that have a religious basis? The answer is yes, if they neither advance nor inhibit religion. Laws against murder do not enhance or inhibit religion because atheists don't want to get murdered any more than anyone else, right? So that would pass the Lemon Test. If you were to declare, I don't know, Sunday to be a day of rest and dictate that all businesses should be closed, that would not pass the Lemon Test because that would only benefit those who believe Sunday is the Sabbath. It would not benefit those who do not. So that wouldn't pass the Lemon Test. But a law against murder would because it benefits everybody regardless of their religion equally. All right, so going forward, Second Amendment, right to bear arms. About as controversial as the First Amendment. Text is, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So what does this mean? Basically, it means you have the right, as an individual, you have the right to possess a gun for self-defense in your own home. This was determined and found to be a right in the Heller case from 2008. Now, there are, as with the First Amendment, some limits to this. You don't necessarily have the right to own a bazooka, for example, or a nuclear weapon. But, generally speaking, yes, you do have the right to a firearm for your own protection. Coming forward, criminal procedures, Fourth Amendment, there's a ban on unreasonable searches and seizures. If the police want to search your home, you probably know they have to have a warrant in order to do it. What you have to do to get a warrant, you go before a judge and show the judge probable cause, i.e. enough evidence to suggest that there's a crime going on there and that you will find evidence of a crime if you search it. The degree of protection, though, depends on the level of expectation of privacy. So you have your highest expectation of privacy in your house. So the standard for getting a warrant to search your house is going to be the highest. You have some expectation of privacy in your car, though a lower one. So you have the bar to get a search warrant for your car is going to be much lower. Exclusionary rule, evidence that's found in violation of the Fourth Amendment cannot be used in trial. Now, a couple things to talk about here. One is if a warrant is not needed if the police see illegal goods in plain view or if they observe a crime. Police can also search a person or area within his or her control immediately following their arrest. So if the police arrest you, say, for a DUI, they can search your car at that point. They don't need a warrant for it. Likewise, if a cop is going down the street and he can see in your window and he sees a meth lab in there, he doesn't need a warrant at that point either. He can just go in. Likewise, a cop can come up and knock on your door. Do you have to open the door when they do? No. But if you do, and they can see in your house, anything they see in there that's illegal is just giving them probable cause. Likewise, too, in like emergency situations, there's exceptions too. Say a cop is walking down the street and he hears screams coming from a house. He's not going to have time to run to a judge and get a warrant and come back because the person's probably going to be dead at that point. At that point, he can kick down your door because the screams would be probable cause. This can get a little hinky when you get when you push it. For example, a cop is allowed to come up and knock on your door. Can they bring with them a drug dog? And if the dog points at your door, is that probable cause then to search your house? Supreme Court has ruled no on that. They used to do that, though. There's also no warrant required for businesses that are subject to health, safety, or administration regulations. So, health inspections, OSHA inspections, things like that. All right, interrogations. Yeah, you cannot be forced to testify against yourself, which means you have the right to remain silent. You also have the right to have an attorney present during any questioning. And these rights are enshrined in the U.S. Constitution, but they're often called Miranda rights because they come from the Miranda v. Arizona decision. And what this decision was it states that anyone, before Miranda decision was handed down, you still had the right to remain silent. You still had the right to an attorney, but the police did not have any legal obligation to tell you this. So in other words, if you don't know, they're not going to tell you. So you might think that you don't have a choice. Miranda argued that he was convicted based on this. Had he known that he had the right to remain silent, the right to an attorney, he wouldn't have answered questions and he wouldn't have gone to prison. And this case made it all the way to the Supreme Court. The Supreme Court ruled now any suspect has the right to be informed of their Miranda rights before they can be questioned. By the way, there's a few things here, though. If a cop forgets to read you your rights, it doesn't mean you go free. It just means that whatever you told them is not admissible in court. So, for example, if you get pulled over for driving erratically and the cop sees a bloody knife in your passenger seat, that's going to be probable cause to pop your trunk. If they find a body in there, then they can arrest you. If they forget to read your rights and you confess to murder, yeah, you can then get your confession thrown out of court, not allowed in court, but they're still going to charge you with murder and convict you most likely because there's enough evidence to get a conviction without your incriminating statements. So you don't automatically walk free just because a cop doesn't read you your rights. Free legal advice. If you're arrested, should you waive your Miranda rights? The answer is, if you're guilty of what you're arrested for, yes, you should just admit to what you did and take the punishment for it. If you're innocent, no, you should not. Because this is not a criticism of law enforcement. Most cops are good people doing a difficult job, but if they've arrested you, it's pretty good indication they think you're guilty. So anything you say, you're just helping build the case against you. So if you're guilty, go for it. But if you're innocent, probably not. Trial procedures. You have the right to an indictment by a grand jury. You have the right to counsel an impartial jury. You have the right against self-incrimination. Once upon a time, the right to counsel meant you only had the right to an attorney if you could afford one. But since the Gideon versus Wainwright decision in '63, all defendants who could spend even a day in jail have the right to an attorney. If you're acquitted, you can't be tried again for the same offense. This is double jeopardy. Once you're acquitted, can you ever be tried again for the same crime? The short answer is no. The long answer is yes. Okay. Typically, the answer is no. 99% of the time, the answer is no. The only exception would be if you commit a crime that is both a state and federal crime. If you're acquitted by the state, sometimes the feds can bring charges against you and get a conviction. This is extremely rare, though. Short answer is, once you're acquitted, you can never be tried for that same crime again. If there's a mistrial, you can be tried again. Mistrial could be a hung jury. Also, if you're convicted and the decision is thrown out, you can be tried again as well. At the federal level, judge determines the sentence if the defendant is guilty, except in death penalty cases. This is only at the federal level, though. Right to privacy. This is not specifically in the Constitution. There is no phrase right to privacy in the Constitution. But the courts have ruled that it is an implied right which exists. And it's becoming more and more relevant today because of cameras, the internet. People probably today have less privacy than they've ever had. You can argue, even though it's not in the Constitution, you can argue that the Fourth Amendment, protections against unreasonable searches and seizures, kind of alludes or implies a right to privacy. You could also argue that the Ninth Amendment, which says you have more rights than are listed here, may also imply it as well. The right to privacy was established in 1965 in the Griswold versus Connecticut case. Griswold versus Connecticut case dealt with birth control. The pill had just hit the market, I believe, in '63, and it changed the world. And a lot of people, it was controversial at the time, a lot of people thought this was playing God, and some states made birth control illegal. Connecticut was one of those states. Griswold sued and argued that she had a right to privacy to purchase birth control pills herself, and the court ruled in her favor, establishing the precedent of a right to privacy. Later on, in '73, more controversial case, Roe versus Wade, the court ruled that this right to privacy also protects your right to have an abortion within the first trimester of a pregnancy. So that's a right to privacy. Other right to privacy rulings, there was a famous case from Georgia where cops served a search warrant on a guy they thought was selling drugs. They searched his home. They didn't find any drugs, but they did find his porn stash. So embarrassing. At the time, pornography was illegal in Georgia, so he was tried for that, convicted. But the Supreme Court overturned it and ruled that you have a right to privacy, protects your right to watch pornography in your own home. In 1961, sodomy was illegal in every state. But in as late as 2005, it was still illegal in some states, including Texas. But this was overturned in the Lawrence versus Texas decision. If you don't know what sodomy is, I would say Google it, but don't Google it at work. Right to die. Those who make their wishes clearly known have the right to terminate life-sustaining care. So if you're a vegetable on life support, if you made your wishes known, you obviously at that point it's too late to make your wishes known. But if you made your wishes known before through a living will that you would want life-sustaining care terminated, then you have that right. Do you have the right to assisted suicide? No. The courts have never found that a person has the right to assisted suicide. Some states have granted people that right, but the feds have never found that that right exists, which means that states can decide for themselves whether or not they want assisted suicide to be legal. Property rights, can the government take your stuff? The answer is yes. Under the Fifth Amendment, what's called eminent domain, the government can take your property if they provide you with just compensation, and it has to be for public use. What does public use mean? What does just compensation mean? Fair market value. What does public use mean? Well, highways and roads would be an example of this. I mean, you look at all the roads now, probably not everybody voluntarily gave up their property so that we could have highways and interstates. So they were seized through eminent domain. Parks would be an example of this too. Schools, hospitals, shopping malls. Yep, Supreme Court ruled in Kelo versus New London that the government can take your property for private developers to build shopping malls or shopping centers. So, short answer, if the government wants to seize your property under eminent domain, you can fight it, but you probably will lose. All right, so close here by saying political tolerance is necessary for liberty in the marketplace of ideas. Civil liberties exist to protect minorities from the tyranny of the majority. How well do we do at protecting all these different rights? Well, that's something to think about. And I'm going to call it a day right now. As always, if you have any questions, please let me know. Otherwise, I will be back to talk to you about civil rights shortly.